Hi, everybody. Welcome to Docs HR. Super excited to spend my morning with you. If you're new here, hi, welcome. Docs HR is a HR consulting firm seeking to provide resources inside to employees and employers on some basic best HR practices and insights and information. Dr. Menta, I have over 17 years experience in HR, so I might know a thing or two, and also, hope to provide that insight to you. I want to put a legal disclaimer out there. I am not a lawyer. I may know the law. I may have, exercised some of them in my role in HR, but if you have a complex situation that wants a legal review, please reach out to a legal counsel. This video does not substitute for legal advice. Just want to put that disclaimer out there. Okay, with that out of the way, today I want to talk about leave provisions. I have some friends who've recently been asking me a lot about leaves because they have no idea. Some people don't read the handbook. Some people don't have time to go to HR. So that's why HR is coming to you, right? And so we want to talk about what leave provisions are in the US, right? And over time, I'm well versed in Canada, so I also go and touch base on Canadian law and Canadian leave provisions. What I love about Canada is their pregnancy and childbirth. Child, it is so good. Anyways, back to the US. So every leave I'm talking about, specific to US employers and employees. That's my expertise. If some stuff sound familiar to outside US, that's great. Please do your research. So, doctor, I'm pregnant. I'm not sure what to do. When it comes to leave or entitlements. Well, I'm having a medical procedure going on. I don't know what to do. Well, there are federal laws that provide job protection. Some can be unpaid for employees to go out and take care of themselves or their family members. There are also state laws, and there are also company specific laws. Now, I want to say that every state is different. So, in addition to the federal, you might want to check out what your state provides. And if you need any consultation, my details are in the this video and then also my handle account information. You can reach out to me like that. So the first one, which is widely known, is the Family Medical Leave Act. I have a couple of notes there so I can share, make sure I'm providing the right information. Um, so the Family Medical Leave Act, right? This act has been around for a while, and it entitles, excuse me, it entitles eligible employees to unpaid job protected leave for either specified family needs or individual needs. And it provides up to 12 weeks paid leave in a 12-month period. Now, who is eligible? What employees are eligible? Okay, so an employer, the one who employs you, has to have 50 employees within a 75 miles, any public agency or private school. Okay. And you, as an employee, must have worked for the employer for at least 12 months, not necessarily consecutives, and have at least worked 1,250 hours during the 12 months. So if you work the 12 months but don't reach the 1250 hours, you might not qualify. There may be other provisions out there, but these are the standard provisions for the FMLA. Now, this is what employees are entitled to: 12 weeks of unpaid time, right? And FML can be taken at once, concurrently, or intermittently, which means broken up over a specific time until the time runs up. The question is, what can you use FML? FML is a federal law, so it affects almost all employees who fall into that category: 50 employees or private, all of that. So, what can you use FML for? We can use FML for self or to care for a family member. Birth of a child and caring for a newborn, right? Placement of a child in adoption, okay? Caring for an immediate family member, which is a spouse, child, or parent, right? And then a serious health condition for yourself and certain qualifying emergencies due to a family's military deployment. And there's another law called USERA that helps with the leave entitlement for military. And, you can also have up to 26 weeks leave in the 12-month period to care for a covered service member, or for that's called a military caregiver leave. So for military, it's a bit longer. Thank you for your service, by the way. But for the basic provisions, it's 12 weeks. Now, how do you ask for FMLA? We'll get into that later on. So, maintenance of benefits. So, while you are out on FMLA, your employer must maintain the employee's group health insurance under the same terms. So, if you have a copay, you have to figure out how to pay that with, if you have a leave management system or your company administers their leave themselves, there's a way to kind of work that out. That's where your HR comes in, right? That's where you reach out to HR to talk about leave benefits and what to go about. They'll walk you through the process. Now, people are scared to take FML because they feel like they'll either be discriminated against or will not return back to their role that they left. That cannot happen. Upon return from your FMLA, which is job protected, you must be restored to the same or equivalent job with equivalent pay, benefits, and other employment terms. One thing I've heard most is, but doctor, if I come back, I feel like I'm either being treated differently, I'm given a different schedule, different responsibilities, kind of like I'm being penalized for taking a leave. That can be quote unquote discrimination based on taking protected leave. We don't want to do that, employers. We don't want to get there. So if an employee is out on a job protected leave, please, upon their return them to their job or find a similar equivalent job, same pay, same benefits. Let's just protect everybody else and just, okay? Ain't nobody got time for that. Okay. So if the employee is aware that they need to take FML, they need to provide at least 30 days notice when the need for leave is foreseeable. However, if it is not, as soon as you are able to provide notice, please do so that your employer and leave can make provisions for your absence. Employers, please, when an employee reaches out, you've got to inform them of their FMLA rights and responsibilities. Even though you're taking the leave, employee, and you know that, oh, I'm protected, there are some things that you do, like certifying the leave, right? Medical certification. Employers may request certification to support their need due to a serious health condition. So some companies work with third-party administrators that administer their leave. And when you reach out to them, they'll help you go through the process, give you some forms to take you to your medical provider. They are going to fill it out. You're going to bring it back. It is important to get that document filled out because that document will certify that, yes, this condition is going on, you're eligible for the leave, and it's protected. If you don't fill out your medical certification, there is no justification to give you. You might be in the hospital, but then again, there's no documentation to justify you being out on leave. And that leave can be denied, and you'll be subject to the company's attendance policies. So please, when you're going through FML or any leave and you have documentation that you need to provide, just provide it and be safe. Again, FML can be taken intermittently on a reduced leave schedule. Okay. Employers, please do not interfere with, deny FML, exercising of FMLA, or retaliate against employees for taking leave. You are just setting yourself up for a big lawsuit. If the employee qualifies it and they have a serious health, do your best to provide it. Now, some states have different provisions. And again, I love California. California is a country on its own because they are employee-centric. But one of the laws in California is the California Family Rights Act, right? It's the state's version of the federal FML, and it has larger provisions. Remember, FML covers spouse, child, and parent, I think. And yes, spouse, child, and parent. But the CFRA in California, let me read to you. It applies to private employees with 5 or more, as opposed to the 50 for FML. So higher threshold, lower threshold, and all public employees, regardless of size. And again, employees eligible for CFRA if they've worked at least 12 months, at least 1250 hours, and are employed with California. Outside of California, you don't qualify, my friend. Now, same as the FML, this employees can take up to 12 work weeks of unpaid job protected leave, bonding with a new child, caring for a family member. Now, the difference between CFRA actually expands who qualifies for family members. I'm going to read the list out. Spouse, domestic partner, parents, parent-in-law, child, sibling, grandparent, grandchild. I think it's time for us to move to California. Anyways, but FMLO does not cover siblings, in-laws, grandparents, and grandchildren. So it's a pretty expansive law. That's different from pregnancy leave in California. CFRA does not cover pregnancy-related disability leave. That is under California's PDL, pregnancy disability leave. Employees can take up to 4 months, followed by the 12 weeks for a total of 7 months job protected leave. Now that sounds good, right? And employers must maintain health benefits during CFRA, as if the employee was. Again, you can't retaliate or discriminate against an employee for taking FMLA employees, and same thing, certification is required and all of that. Sometimes the CFRA and FMLA can run concurrently, except in cases when the CFRA is, broader or covers someone that is not covered under FML. Pregnancy disability does not count against the CFRA entitlement. Two separate laws. Again, if you have any questions or need more clarification or need guidance on what the leave provisions are, my details are in the account. But if it's a complex thing, reach out and get some legal advice. I'm happy to provide some legal resources as well. So that is our main FML. Then we have the ADA. I'll go another video on accommodations and all of that. The next big one that came up is the Pregnancy Workers Fairness Act. This act is new, and it was instituted in June 27, 2023. I remember because I was pregnant. And, it covers employers with 15 or more employees, including private businesses, public entities. So 15 or more, you get it. And it is to mandate reasonable accommodations for employees or applicants with no limitations related to pregnancy, childbirth, and related medical conditions. And doing so should not pose an undue hardship. Okay. So this is different from the American with Disabilities Act. I'll do a whole video on that. I know that's a very complex topic. So, reasonable accommodation requirements. Employers must engage in the interactive process with the employee to determine the appropriate accommodations, which may include modified work schedule, remote work, light duty, time off for recovery of birth, right? And I want to say that employers cannot deny a job opportunity due to accommodations, require leave if another accommodation. Just try to work with the employee, exhaust all options before we deny accommodation under PW or leave under PWFA. And this PWFA applies to all qualified employees who can perform the essential functions of their job with or without an accommodation, and who are temporarily unable to perform these functions due to a covered condition. Okay, pregnancy is temporary. Sometimes after pregnancy, employees also continue to have childbirth-related illnesses, and PWFA covers that. One thing I want to talk about under the PWFA is documentation. While the PWFA does not explicitly require documentation, employers are allowed to request documentation under certain conditions. However, this must be reasonable and not burdensome. So, under the ADA, documentation must certainly be required to evaluate, the condition and how best we can accommodate. PWFA is more lax. It limits employers on what they can ask and what they cannot ask. You may request confirmation from a healthcare that the employee has a condition limited to related to pregnancy or childbirth, some description and suggested accommodations, but the documentation must be limited only to information necessary, okay, to confirm the limitation and the need. There is no need for all of data to be put in that documentation. I'm pregnant, my due date, suggested accommodations, that's it. And overly burdensome documentation may be considered unlawful. Unlike the ADA, where you can reach out, you can ask for more documentation and all that, PWFA is different. And employees must be prompt in engaging in the interactive process without delay while documentation is pending. Okay, now, PWFA. You have to accept informal notes, again, doctor's letter or statement without requiring extensive medical records. Maintain documentation in a confidential file. Okay, PWFA is enforced by the EEOC, Equal Employment Opportunity Commission. Yeah. Now, PWFA does not replace Title VII Pregnancy and Discrimination Act, ADA for pregnancy-related disabilities, or FMLA. PWFA is a standalone. It's different. So, I wanted to call that out. Now, I want to pivot to other general leaves that we may have, that you may have come across in your company. We may have the short-term disability, right? Which some companies offer, some companies do not. The specific provisions depend on the provisions of your company, but it is an employer-sponsored STD plan and is usually available to employees after a certain period of employment. It could be 30, 60, 90 days of employment, depending. And some policies require enrollment during open enrollment or within a new hire window, right? And it typically covers non-related work illnesses that prevent employees from performing their jobs, surgery recovery, pregnancy and childbirth recovery, illness, injury, mental health, depending on the plan of the company. Okay. Sometimes the SCD does not provide a full pay. Some provide a full pay up to a certain number of weeks, and then it reduces to typically 60 to 70%. I know I got STD for 6 weeks, and after that, it reduced to 70%. Okay. The benefits can last anywhere between 9 to 26 weeks, again, depending on the company plan. But common maximum in case of disability related to pregnancy after having a child is 6 weeks for normal birth, 8 weeks for cesarean, and then 13 to 26 for other disabilities, right? And I'll share confidentially, I had preeclampsia with my little one, so my STD kind of kicked in early because I had to get out of work early, be on bed rest, and all of that. So it depends on the provisions of your company. For STDs, there is usually a 7-day waiting period before benefits begin. That sometimes waits for hospitalization. However, your company will tell you what the provisions are. Some allow you to use PTO during that time or sick leave. And the employee must be continuously disabled during that time. STD can run concurrently with FML and can be coordinated with PTO for some and other state leaves. Um, kind of like that. STD also requires paperwork to be certified by your medical paperwork. Sometimes you need a return to work duty or light duty. You need a fitness for duty form to come in. Now, sometimes workplace injuries are covered under workers' compensation, and that can be another topic I'll do. Um, okay, so with that, there's also a long term. Some people go on short term disability and then figure out it's long term, maybe cancer or something. Then the company also has long term disability provisions for the employee. Some employees, well, some employers, once they reach the long term disabilities, they tend to notify the employee that we can't keep you long term. Your benefits will continue, however, we will separate. At that point, your role is no longer job protected. So employees can separate. However, this sometimes does not impact your benefits under long term. Then we come to paid sick leave. Some states offer paid sick leave. I know Arizona is one of them, California is one of them. They are state specific. Um, and there's no national requirement. However, California, New York, Massachusetts, and Arizona, they require employers to provide paid sick leave. The common standard is 1 hour of paid sick time per 30 hours or 40 hours per year. So I want to be mindful of that. So whatever state you're in, you might want to check what your benefits are. There's that one thing, another one, a few other ones that I want to call out. Military leave, USERA, this protect job and benefits for employers on military duty. Applies to all employers, regardless of your sex. You could be one, you could be 10, you could be 100. You need to comply with USERA. And it guarantees reemployment and continuation of benefits upon return. We also have the jury duty and witness leave. Employees are entitled, but not all employers provide that. So check with your employer. Some states require paid leave, paid jury leave. Others do not. So again, you gotta check your state. I'm available for a consultation. Voting, some states also require employers to provide time off to vote and pay that. Now, bereavement leave. It's hard to lose someone, right? And so Um, bereavement leave is not federally mandated, but some states, like Oregon or Illinois, they require employees to pay and offer benefits leave. But many employees voluntarily provide 3 to 5 days. Uh, some employees are so generous that they provide up to 15 business days for nuclear families, and then 5 days were extended, right? So, depending on your company's provision, you can find out if the benefits should be in your employee handbook, or you can just ask. And then vacation pay time off, majority, there's no federal requirement, but majority um, of employers provide paid time and vacation time. Some states do not pay out upon termination. Some states do. So again, check about your state. California requires payout of accrued vacation at separation. Utah doesn't. Texas doesn't. So other states do not. Now, there's also some states for domestic violence or safe leave, right? When an employee is going through something. California, New York, Washington, those employees are entitled to protected time off to seek medical attention, attend a court, relocate, and access and support services. Religious and disability accommodation leave. That is under the Title 7 and ADA. I'll do another video on that because I don't want to go past 30 minutes on this one. Employers may be required to grant reasonable leave for observing religious holidays and attending medical treatment or rehabilitation due to disability. So that is all. Now, how do you access this? Go to HR. I know that some employees have a thing about going to us HR, but let me tell you, not all of us are scary. I think that we are here to make sure that you have a healthy work balance and that you get all the resources you need to do your job. So, if you are having a medical condition, inform your HR early, right? If your HR has a third party that provisions the leave, just ask for the leave information and go to that. I know sometimes some of us hesitate to share confidential information. If we do that, go ahead. You work closely, so you ask HR for your leave contact or how to start a leave. You can follow that process. It's almost always confidential. Um, I am a stickler for not. I can tell. I usually tell my manager, "Hey, I have a situation. I'm gonna reach out for leave." You, as an employee, are not required to divulge every medical history to your manager. No, it is a very confidential process, and I know employees feel uncomfortable sharing that due to fear of retaliation, discrimination, or being treated differently. So, if you are reaching out to HR and are not comfortable about sharing the information, ask them what the process is to apply for a leave. If you are having to deal with the HR, if it's in house, then really make sure that it is a confidential information and you don't have to go through your manager to seek for help. You can reach out to your manager to ask about leave, also they can direct you, but you don't have to share all your life story with your manager. Managers, do not engage in medical related conversations. If your employee brings it up, great. Direct that to the HR or resources that they need. Do not. The reason why I say this is sometimes managers put themselves in a spot where they ask questions that they are not supposed to ask. And then it turns around and employees start using that and say, hey, my manager is discriminating against me because I disclosed my medical condition. So I'm being discriminated or retaliated against or whatever for disclosing that. So we want to save ourselves as managers and employers from that pitfall and always direct people to HR. Okay? We are not monsters. We are here to make sure that everybody's safe. So with that, I'm excited to have gone through that. I will put some notes and summary in this page. My detail is below. Reach out to Docs HR so we can support you. You are entitled, if you work in the US and you fall into these categories, don't be scared to use your leave. Don't be scared to use the benefits available to you because as you've worked, you've earned it and you deserve to use it. If you have further questions about any leave, I know other states have other leaves that I haven't touched on, or if there's any leave you want me to break down for you, list it out in the comments or DM me and I'll do a video on that. But with that, thank you for your time. And if you need anything else, docsirhr.com, reach out and we can connect. And I'll be back with maybe a video on American Disabilities Act and what provisions there are for both employers and employees. So check it out. Please share this video. Someone might need it. And I wish you all the best and have a wonderful day. Till we meet again, lead with empathy.